This is Michael Popok, Legal AF After Dark. You know what that means? That means lawyers talking about law and politics the way only we can on Legal AF on the MeidasTouch network. This past Saturday, the two co-founders of Legal AF, Bad Meiselas on one side, me, Michael Popok, on the other. We talked about the Colorado Supreme Court oral argument, the ridiculous arguments made by Donald Trump's lawyers to argue that because Donald Trump didn't swear to the right oath to defend the Constitution, he can't be removed from the ballot in Colorado as an insurrectionist and person who engaged in insurrection and rebellion against our Constitution. Listen to Ben and me. Draw your own conclusions.
This should be front page news, Michael Popok, that Donald Trump's lawyers are putting it in writing. They're arguing in their brief that Donald Trump did not take an oath to, quote, support the Constitution of the United States. That is in the summary of argument to the Colorado Supreme Court. Then doubling and tripling down on that, Donald Trump's lawyer went in front of the Colorado Supreme Court and argued that the Confederate president, Jefferson Davis, basically would have been able to run for president, and that the Democratic Party could conceivably nominate Obama for a third term, that there really aren't limitations at all put on people when it comes to the presidency because Donald Trump and Trump's lawyer argued a president is not an officer and doesn't take the oath to support the Constitution, so those limitations don't apply. How absurd and dangerous of an argument can you be, or can you get? Here's what the oath of office says for the presidency. Quote, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So to argue that, number one, a president who takes an oath to execute the office of the presidency is not an officer is utterly absurd, and even making that argument is totally in bad faith. And to argue that that oath that I just read does not encompass an oath to, quote, support the Constitution of the United States is complete and utter garbage. And it should be front page news that Donald Trump's lawyer made that argument before the Colorado Supreme Court. It should be front page news that Donald Trump's lawyer argued that there are no limits. The Jefferson Davis example, the third term example, those are red alerts. And just to remind everybody, the lower trial court found that Donald Trump was an insurrectionist, engaged in an insurrection for purpose of the 14th Amendment, Section 3. But based on this tortured analysis, found that he was not an officer within the meaning of the 14th Amendment, Section 3, which states that no person shall be a senator, representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States, who having previously taken an oath to support the Constitution shall have engaged in insurrection or rebellion. The judge said because the presidency is not specifically mentioned in Section 3, but Popok, as you pointed out, the catch-all is or hold any office. You take the oath of office that I just read. I mean, that's where people get very frustrated, would be putting it lightly, when it comes to how people manipulate law and language. But it is important that we make very clear how law, how language is being manipulated for these nefarious purposes. So people, the legal AFers, the Meidas Mighty, everybody can be armed with the knowledge to know when they're being gaslighted. And that's why I wanted to close with just talking very briefly about what went down in Colorado and just arm you with, that's the oath of office. This is what the 14th Amendment, Section 3 says, and how and why this is not repeatedly front page news just goes to show you, unfortunately, how legacy media is not doing its job, and how and why it's so important that everybody watching this share this with people, tell friends, coworkers, family members, subscribe to this channel, and let's just read it together. Let's just read what these things say, and let's show you what the people are saying. Popok, I want to throw it to you for your analysis.
Yeah, and a shout out to legacy media in other ways. We're not here to suggest that there's nothing good that comes out of what we refer to as legacy media. There's plenty of stories and analysis that I get or I pick up in places like The Guardian or Bloomberg Law or different places, because they've got intrepid reporters that are not responsible for what editorial page it ends up on in their paper, and are out there trying to break news. MeidasTouch now is able to break news because it's got people focused on these issues. But we rely on the news feed, so to speak, that comes from these kind of media, legacy media, original media. But that's not the criticism we're making. Not that they don't serve a useful purpose. It's that in certain ways, whether it's on the publisher side or the editorial side, that they are abdicating their responsibility to bring to the surface and the way they prioritize things in their newspaper or on their feed, on their social media feed matters. And that's why we think, an open lane to do what we do. Colorado, still a head scratcher for me as to why. I mean, I know why we're talking about it, but like why we have to talk about this particular thing. First of all, I'd be embarrassed if I were Donald Trump to argue his primary argument that you can't get me on this one because I didn't take the right oath to support the Constitution. I'd be embarrassed to make that argument, but nothing embarrasses. Every time I think we hit rock bottom, Donald Trump and his lawyers start to dig and go beyond that rock bottom. So nothing surprises me. So I would never make the argument because it's silly. It's also silly and wrong-headed from a legislative history standpoint. The reason that the trial judge got it wrong, which is why we're here, she got so much right in that decision, but got it fundamentally wrong at that last moment. On the 1-inch line, she did not score the touchdown and fumbled it out of bounds, fortunately for the appellate court to pick it up, is because her analysis was, well, I looked at all the legislative history, and there was an earlier draft of the 14th Amendment, Section 3, and that had the president in it, and then they took it out. So they must have taken it out for a reason. They just don't want the president. They don't want it to apply to a president. Like, what? They took it out, and the next draft that they used to adopt added for the first time the catch-all language that expanded the Article 14th Amendment, Section 3, to all people who take an oath of office, like the president, to support, defend, whatever you want to call your relationship with the Constitution is. It all boils down to the Merriam-Webster definition of support. For the president, it's support plus. It's not support minus. It's more than support. Commander-in-chief, defend, preserve, protect. Those are the things you can do in your office. Those are the trappings of your office. Everybody else, support. It's all support at the end of the day. And that's what the briefing to the Colorado Supreme Court said. So it's sort of a ridiculous, hair-splitting, how many angels dance on the head of a pin type analysis. And she just got it wrong. I mean, there's no other way to put it. So we knew the only issue that was framed for the Colorado Supreme Court was because she already ruled that he was an insurrectionist. He did engage in insurrection or rebellion against the Constitution. It's just that she said that doesn't apply to him, that particular provision of the Constitution. So that's the argument. The thing that I found troubling about, and you did a good report on it, and I watched it with the live feed of the Colorado Supreme Court oral argument, is that they seem to be stepping the bucket again on an issue that somebody like Michael Luttig, the lion of the Federalist Society judges of all things, in a piece that he did about a week or two earlier, said the lawyers and the judges are getting all of this wrong. The sentence that you read out loud, Ben, in the 14th Amendment is not engage in insurrection or rebellion against the United States, which would then have you start debating what happened on Jan 6th, and was it an insurrection, and were there pitchforks, and how many people died, how many weapons were in their backpacks. That's not what it says. It says against the same, and the same is referring to the Constitution. So the proper reading of that sentence is to engage in rebellion or insurrection against the Constitution. And his argument, which is right, is that Donald Trump engaged in that type of insurrection or rebellion against the Constitution when he refused the peaceful transfer of power and every step of the way. Not Jan 6th particularly. There was just a lot of like oral argument about knives and weapons and backpacks. And I'm like, this is exactly the rabbit hole they were not supposed to go down. They should be focused on the Constitution and his constitutional duties. The other thing I found was interesting, I don't know if you caught this, Ben, in the New Yorker magazine, they had a fascinating piece about Jefferson Davis and the trial of Jefferson Davis. And the author there posited, and it's a good thought experiment, if they had been successful in the trial against Jefferson Davis at having convicted him and adjudged against him, we would be less squeamish as a people today about doing it against Donald Trump. But because Donald Trump is the first one in our history, because of his bad acts, he's the first president. Well, I mean, those would argue that Jefferson Davis didn't cover himself in glory in departing the Union and becoming the first president of the Confederacy. But I put them both up on the Mount Rushmore of insurrectionists and traitors, in my own view, as people know. But if we had been successful as a country to convict and find judgment against Jefferson Davis, we'd be less squeamish today about it. But there's no doubt, and this was in the legislative history that's at the core of this argument, there's no doubt that the people in real time contemporaneous with Jefferson Davis, the traitor, said that the 14th Amendment, Section 3 would apply to him and should apply to him. So if it would apply to him, how could it not apply to Donald Trump if he engaged in a similar act against the Constitution? I hope that the Supreme Court of Colorado gets it right on this particular issue. It's the last stop on the train related to it. I don't think there's a U.S. Supreme Court way to handle this, although I want to hear your view on that. But we're on a knife's edge here with how this decision comes out. I didn't take a lot of confidence about how this August panel of Colorado Supreme Court justices is going to rule on this most important issue, having now watched Minnesota and Michigan at their highest levels punt on the issue and basically take themselves out of the running for making a decision in time for the November election.
I mean, if you go and look at Donald Trump's brief, it would seem to be an insurrection against the same, referring to the Constitution by saying he did not take an oath to support the Constitution of the United States. I mean, again, I don't want to lose sight that that's actually in his briefing papers. And to your point, Popok, no court here on this issue wants to be the first. The important thing to also kind of reflect upon, though, is the courage of like Judge Tanya Chutkan in the DC federal case, the DC circuit, and the balancing of like when Donald Trump is trying to argue that imminent harm and imminent threat, clear and present danger for him to be gagged basically requires somebody to be killed. Right? And Judge Chutkan rejects that. The D.C. Circuit Court of Appeals rejects that. The clear and present danger balancing test requires that there be not like someone actually getting killed. And I just think similarly, with all of these courts not wanting to be the first and trying to parse, was an insurrection this time frame and how many hours makes an insurrection and whatever their excuses are to try to avoid, engage in kind of constitutional avoidance at this stage. The problem is that there is a clear and imminent threat to our democracy at this very moment. And courts need to meet this moment, even on issues that are novel. And I do not think it's okay for courts to try to punt it and parse words and gaslight us. But I also think it is important for an educated population to let the courts know, to let the Fourth Estate know, to let the world know how we feel about this. And we all need to be armed with the data and information, because the same way these courts are sometimes reacting to what they believe to be the pressure that could be directed their way by the wannabe authoritarian, and authoritarianism and fascism really relies on this public perception of strength, even when it's not there. The silent majority of Americans who support our democracy, support normalcy, who truly support the Constitution, not in some performative way, but in the real, authentic way of life, that silent majority can't be overpowered by these voices of relentless voices of fascism and disinformation. And
that's a great example of what we do every week, twice a week, only on the MeidasTouch Network on a show we like to call, wait for it, Legal AF. Right, it's exactly what you think. We sit at that intersection of law, politics, and justice, so you don't have to. And if you like that kind of stuff, who doesn't like that kind of stuff? And you know about us already, welcome back. Thank you for following and being part of the audience and movement of Legal AF. If you have no idea who I am and what I'm talking about, I'm Michael Popok. That was Legal AF. And join us every week, twice a week, Wednesdays, Saturdays, 8 p.m. Eastern Time. And then on hot takes like this one that the leaders of Legal AF do every day, every hour, only on the MeidasTouch Network to keep you apprised of developments at that same intersection, law, politics, and justice. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.